everyone. It's a pleasure to have all of you here, and my pleasure to talk to you a little bit about the Supreme Court's decision in Google versus Oracle, which came down just a week ago on Monday. Before I get started, I want to thank the Internet Law Society for inviting me to give the talk, and for the Santa Clara students who are in attendance. The Wellness Task Force has put together a fun event for a week from Wednesday, a trivia night, and being the former two-time champion on the TV game show Jeopardy, they've asked me to host a trivia night. So that'll be on Wednesday, the 21st at 6 p.m. Look for the link from the Wellness Task Force for trivia night, and hope you'll be interested in participating in that. So for Google versus Oracle, in order to understand the implications of this case, I think you need to know a little bit about copyright law, a little bit about programming, and a little bit about the history of how copyright law has been applied to computer programs. And then we'll talk in detail about the decision. So with regard to copyright law, first, well, just to give you the headline from the Supreme Court opinion, there were two questions presented to the Supreme Court: whether copyright protection extends to a software interface. And in this case, a software interface was defined somewhat narrowly as lines of computer code that allow developers to operate pre-written libraries of code used to perform particular tasks. And the second question presented was whether, as the jury found, Google's use of a software interface in the context of creating a new computer program constitutes a fair use. And just to give you the headlines first, before we talk about the background, the Supreme Court decided not to address the first question. We assume, for argument's sake, that the material was copyrightable. And instead, they resolved the case on the grounds of the second question. We hold that the copying here at issue nonetheless constituted fair use. So I'm going to be going through that and explaining why I think they did that and what the ramifications of their holding are. But that's sort of the headline. But now let's take a look at the bit of the background that we need to understand the case. Section 102A of the Copyright Act, 17 U.S. Code 102A, it says that copyright protection subsists in original works of authorship fixed in any tangible medium of expression. And then it gives us 8 categories of works of authorship. Literary works being the first category, motion pictures and other audiovisual works being the 6th category. And literary works are further defined in the Copyright Act. All of the definitions in the Copyright Act are in Section 101. So Section 101, literary works are defined as works expressed in words, numbers, or other verbal or numerical symbols or indicia, regardless of the nature of the material objects in which they are embodied. So this definition of literary work is broad enough to include computer code. And this is the section of the statute that under which computer code has been protected. There is a definition of a computer program in Section 101. A computer program is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. And as we talk about program, you'll see that programs used directly in a computer are in the form of binary code, 1s and 0s. Programs used indirectly in a computer are in the form of source code, which needs to be compiled into 1s and 0s for them to operate the computer. Now, the Copyright Act doesn't expressly say that computer programs are protected. It just uses this definition. But it does have an exception for certain uses of computer programs that are exempt. So the protection is implicit because of the definition of literary works. But then we have to reconcile this with Section 102B. What Congress giveth in 102A, it taketh in 102B. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. regardless of the form in which it is described, explained, illustrated, or embodied in the work. So section 102B is a general limitation on the scope of copyrightable works. We tend to refer to it by its shorthand, the idea-expression dichotomy, but notice that it excludes any procedure, process, system, or method of operation from copyright protection. The question is, well, what does that mean for computer programs? Computer programs, sort of by definitions, are procedures, processes, or methods of operation. Surely that can't mean that all computer programs are exempt from copyright protection, but it's the scope of section 102B and how we apply it to computer programs that creates some difficulty. Now, once we have a computer program that's protected by copyright, protection is also subject to the fair use doctrine. So the fair use doctrine is in 17 U.S.C. section 107. It literally says the fair use of a copyrighted work is not an infringement of copyright. That's all it says. The fair use of a copyrighted work is not an infringement of copyright. It leaves it up to courts to decide in a particular case whether something is or is not a fair use. It gives us two sources of guidance in the statute. First, it gives us 6 examples for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. Those 6 examples are not automatically fair use. We still have to evaluate them, but they're the sorts of things that Congress had in mind, the sorts of things that are more likely to be fair uses under the circumstances. They're also not exclusive. You could have additional purposes, but obviously you're in much better shape if you can analogize to one of those purposes or try to fit within them in some way. And then the statute says, consider 4 factors. First, the purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth, the effect of the use upon the potential market for or value of the copyrighted work. Now, obviously, if you're already familiar with copyright, those principles are familiar to you, but I wanted to make sure that we included everyone who has not yet taken intellectual property, has not yet taken copyright, and bring them up to speed. Next thing you need to know a little bit about is computer software. So computer programs are written in a high-level programming language, such as Fortran or COBOL. Those are very old languages. BASIC is what I studied when I was in college and took computer programming. C++, more recent. Java, of course, the programming language at issue in this case. High-level programming languages are more or less readable by humans, right? You have to be trained in how to do it as a programmer, but the symbols are readable by humans. You can look through it and see what the program is going to do. But the computer can't operate on that directly. A program written in a high-level language is called source code. The computer cannot operate that indirectly. Computers operate only on instructions expressed in binary code, consisting only of 1s and 0s. 1s and 0s, on and off, that's how computers operate. So a program that's written in a high-level programming language, source code, must be converted or compiled into an object code by a computer program called a compiler. Right? So your programmers write in source code, then a compiler takes that source code, translates it into 1s and 0s that the computer can now read and operate on. The process can be reversed to some extent. A program called a decompiler can convert binary code into a low-level code that somewhat resembles source code. It's typically not possible to go all the way back to the source code. Certain things are lost, particularly the comments, but enough so that somebody can figure out what the source code was, can figure out how the programmer did what they wanted to achieve. And in the so-called first generation of software cases, courts established that computer programs are protected in both their source code and their object code forms. Source code and object code are words expressed in verbal or numerical symbols or indicia, so they are eligible for copyright as literary works. But then we had to deal with the so-called second generation of software cases. So we've established that if you copy code verbatim, if you copy source code verbatim, if you copy object code verbatim, that's going to be copyright infringement. But the second generation of cases, software cases, to what extent are we going to extend protection to the so-called structure, sequence, and organization of a computer program? And in particular, important for this case, to what extent are we going to extend protection to so-called interface specifications? Now, interface specifications define how computers pass data from one place to another, from the machine to the program or from the program to the machine. And or interface specifications might also specify how humans interact with a computer program. So at the first level, specifying how the computer program interacts with the machine or how it interacts with other types of computer programs. We had several cases in the 1990s that sort of indicated that protection for computer programs was very narrow and that certain things weren't protected by copyright. So the Computer Associates case, Second Circuit, 1992, in determining copyright infringement, the court should filter out elements that are not protected by copyright, including elements that are dictated by external factors or external considerations. So among the things the court said, we should filter out the mechanical specifications of the computer, compatibility, elements that are required for compatibility with other computer programs, computer manufacturer design standards. Any elements of a computer program that govern the interface between the computer program and the machine, or between the computer program and the other program. Those interface specifications, the Second Circuit has not said, is not protected by copyright. The Ninth Circuit reaches a similar conclusion in the Sega Enterprises versus Accolade case, holding that because the functional requirements for compatibility with the hardware is unprotected, reverse engineering or decompiling is a fair use. So in the Sega versus Accolade case, Accolade reverse engineered Sega video games in order to figure out what made them compatible with the Sega Genesis computer system. Accolade wanted to write its own video games, its own creativity, but they wanted to make them compatible with the Sega Genesis. So they had to reverse engineer Sega programs to figure out what was in there that was needed to make it compatible. And then they copied only what was necessary to make it compatible. The Ninth Circuit says the interface specification, what's necessary to make it compatible, is not protected by copyright. And therefore, in the course of discovering that, you're allowed to reverse engineer the entire program, so long as what you ultimately end up with only uses what is necessary for compatibility. It had the same holding in the Ninth Circuit in the Sony Computer versus Connectix Corp in 2000. Well, what about, so these are all program to machine or program to program compatibility. What about human interfaces? And here the precedent case in the mid-1990s is the Lotus versus Borland case. It was decided by the First Circuit in 1995. And as you see, it went up to the US Supreme Court. The US Supreme Court granted cert, but one justice was recused, Justice Stevens was recused, and the Supreme Court split 4-4. So this decision was affirmed by an equally divided court. Nonetheless, the feeling was sort of that had Justice Stevens participated, he likely would have affirmed. So this became a precedent that was widely followed or widely accepted in the computer programming industry. So in Lotus versus Borland, Lotus had developed a leading spreadsheet program, Lotus 123, that included an array of commands for the user to use that were arranged in pull-down menus. There were 469 commands with simple labels such as copy, print, quit, arranged into more than 50 menus and submenus, right? So it's a menu command hierarchy or interface specifications, but these are human to computer program interface specifications. Borland developed a competing spreadsheet program, Quattro Pro, that had its own user interface and its own menu commands. But Borland had a problem because people had learned how to use Lotus, and people had become very proficient using Lotus. They could type on the keyboard very quickly using the commands with which they were already familiar. So it was difficult to get them to switch. So in order to facilitate switching, Borland also provided an optional Lotus emulation interface that worked with Lotus commands, so that if you decided not to use the Borland interface, you could use an interface that resembled Lotus, that would respond to all of the Lotus commands. And in doing so, they had to copy the entire menu command structure. But users who were already familiar with Lotus could switch without having to learn new commands or rewrite macros. So the First Circuit in Lotus versus Borland held that the Lotus menu command structure is a method of operation that is excluded from copyright protection by 102B. It's the method of operating the spreadsheet program. The menu command structure is the means by which the user operates it. The user cannot operate Lotus without using the menu commands. And even though Lotus made expressive choices in selecting and arranging the menu commands, the specific words that it chose to use are still essential to the use of the program. Because it's a method of operation, that menu command structure, those interface specifications, are not protected by copyright. The concurring judge, Judge Boudin, said, the key to understanding this case is that users have made an investment in learning Lotus. And he compared that to the investment that people have made in learning the layout of a QWERTY keyboard. Right? The QWERTY keyboard is not the most efficient way to lay out a keyboard, but the problem is that everybody has learned how to use the QWERTY keyboard, so that if you want to make a computer, you got to have the keys laid out the way that everybody is used to using them. It's become a standard that's familiar to everyone. Trying to get everyone to switch is going to be nearly impossible. And so Judge Boudin said, well, because users have made this investment, they should be entitled to take the investment with them when they switch to another program. So I think Borland should win. How should it win? Either because it's not copyrightable, or perhaps because it would be a privileged use. So an alternative to the method of operation analysis would be to recognize some sort of privileged use. He recognized that fair use would be used to recognize some sort of privileged use. But he thought that a copyrightability ruling might be cleaner. Fair use would entail some uncertainty, would entail some delay, would entail much greater litigation costs. If you simply hold that the interface specifications are not copyrightable, that's cleaner. It's easier to decide that on summary judgment. So the US Supreme Court, as I said, took cert, granted cert in the case. Justice Stevens was accused. Supreme Court divides 4-4, affirms by an equally divided court with no opinion. Nonetheless, Lotus versus Borland became a precedent. And the software industry more or less accepted Lotus versus Borland and thought that interface specifications in general were not copyrightable. Things that you need for compatibility with a machine or with a computer program, that was generally accepted. Things that you needed for compatibility with humans, the human to machine interface, somewhat more controversial, but nonetheless, more or less widely accepted in the programming industry. That's why some 20 years later, 2 decades later, when the Oracle versus Google case comes along, comes to a great shock for programmers to realize that the Federal Circuit doesn't necessarily agree. So with that background, I'm going to move to the facts of Oracle versus Google. So this starts in the Northern District of California. It's both a patent and a copyright case, but the jury rules against the patent infringement claims. So it ends up being a copyright case, but that does have significance for the later appeal. So what are the facts? Well, the facts involve the Java API, the application programming interface for the Java language, right? So back in early 2000s, Sun Microsystems develops the Java programming language. It's open, it's free for everybody to use. The programming language is free to everyone to use, but Sun licenses the Java API for use with the language, right? So what is the Java API? What is the Java application programming interface? The Java API consists of a large number of pre-written programs organized into 166 packages 3,200 or more classes, and more than 10,000 methods. The methods are tasks that a computer programmer might want to do, right? So there are lots and lots of tasks that a computer programmer might want a computer to do. Certain of them are very basic, the things that you're going to use over and over. And back in the earlier days of computer programming, you pretty much had to reinvent the wheel every time. You were writing all of these basic tasks over and over and over. And everyone's like, no, it makes much more sense to have libraries of code. It makes much more sense to have certain basic tasks that you're going to use over and over, have those pre-written, and then you can just sort of plop them in, right? So the Java API has a bunch of these pre-written programs, 10,000 different methods that are already pre-written, and it gives a name to each one, the name of the method. And then it organized those methods into classes. It organized those classes into packages so that you can find the method that you're looking for. And if you're a programmer, you don't have to recreate the wheel. You don't have to do all of these basic tasks by scratch. You just have to learn the names of those methods, right? And if you've learned the names of those methods, then it's going to be easy to program in Java. You can incorporate a bunch of pre-written tasks into your larger computer programs as you're programming in Java. So you've got the Java API, 166 packages, lots of classes, lots of methods. And in 2005, Google is negotiating with Sun Microsystems to get a license to use and adapt Java as an open source platform for mobile devices. So they were talking, they were negotiating because Google wants to use the API. They want to customize it for smartphones. And it's the open source thing that's a bone of contention. Google wants this to be very open source. Sun Microsystems wants to make sure that programs comply with its philosophy. And so they end up not agreeing. And instead, after failing to reach agreement, Google uses the declaring code of 37 packages. 37 packages that contain about 600 classes, that contain about 6,000 methods. But Google wrote all of its own implementing code. And you're like, whoa, slow down, Professor Ochoa. What the heck is declaring code? What the heck is implementing code? So let me give you an example that was used throughout the case, right? So here's an example of a simple method written in Java. And you're like, whoa, computer programmer. If you're not a programmer, how do you read this, right? Well, so the 3 lines at the top in blue that I've highlighted in blue, that's the declaring code. And then the 2 lines here that are in burgundy is the implementing code. And you can see the implementing code is contained in the burgundy brackets, and the declaration is contained in the black brackets. Okay? So what does this tell us? Right? This tells us that this belongs to the package lang for language. It belongs to the class math. The name of the method is max. And it tells us the inputs and the outputs. We're going to have two numbers as inputs, integer x and integer y. And we are going to have an integer as the output. Right? So this is going to take 2 numbers and it's going to give us a number. And in this case, it's going to compare the numbers and just give us the larger one. So this is a very, very simple program. Obviously, in most programs, the declaring code is always the first line of the program, right? So again, the declaring code in blue, that's always the top of the program. And then the implementing code follows. In most programs, the implementing code will be much longer than the declaring code. In this very simple program, they're about the same length. The declaring code's just a bit larger. So in order to invoke this method in a program, the programmer is going to call the method. So we call these method calls. And the programmer will type integer equals java.lang.math.max and then give the inputs, right? So again, these are the 2 letter numbers that are the input. Here's the output, right? And of course, these are variables. You can be drawing the inputs from a different place. But you always have this format, java.package.class.method, right? So this is the language package, the math class, and the max method. Max is the name of the method, and it's organized in the math class and in the language package. And again, what Google copied was out of 37 packages that contain 600 classes and 6,000 methods, Google copied the declaring code for each of those packages. The declaring code defines the inputs and outputs. The declaring code names the method, and the declaring code organizes those methods into packages and classes. Why did Google copy this declaring code? Because the declaring code defines the method call. And the method call is the reason, that is the way in which the programmer invokes the method, right? The programmer doesn't have to know what goes on under the hood. The programmer doesn't have to know all of those pre-written programs. Programmer only has to know the names of the method and the classes and packages. And then they just give you the name of the method, give you the inputs and outputs, and that automatically invokes this in the computer program. Now again, Google did not copy the whole API. They did not even copy all 37 packages. They copied the declaring code. They wrote all of their own implementing code, right? So instead of licensing that from Java, which they should do, right? Or not which they should do, but which they asked to do, right? Instead of licensing it to Java, which they asked to do, right? They could have paid Sun money. They could have used the whole implementing code as well as the declaring code. Instead, they copied only the declaring code and they wrote all of their own implementing code. So I'm seeing some comments in the chat room. We don't call it declaring code. We call them just declarations. That's much simpler. Agreed. And the declaring code are what I refer to as interface specifications. They specify interface specifications, specifying the interface between the human programmer, just need to know the names of the methods, and the software that is going to implement those methods. So that's what was copied. That's what it's all about. They had a trial. And at the trial, the jury found that Google had copied the declaring code, the declarations of 37 Java packages, and that the copying was not de minimis, right? Not a big surprise. Google had pretty much admitted they copied this stuff, but they said it wasn't copyrightable. That's a matter of law for the court to decide. And so, but the court asked whether it was fair use. Jury could not reach a verdict on whether it was fair use. So the court has to decide, is it copyrightable? The district court held that the names and declaring code of each method were not protected by copyright, that it was part of the method of operation for the Java programming language. And so that these declarations were not protected, not copyrightable. Each method specification is an idea. Each implementation is the expression of the idea, right? So the idea is the method. It's what it accomplishes, the inputs and the outputs. The names of the methods are not individually copyrightable, but the whole group could be copyrightable, selection and arrangement. Nonetheless, the court holds structure and organization of the API into packages, classes, and methods is not protected by copyright because it is a system or method of operation. That was the district court's ruling. Goes up to the federal circuit. Why does it go to the federal circuit? Because the case originally had patent claims. And even though the patent claims are no longer part of the case, the patent claims were resolved by the jury against Oracle. Oracle isn't appealing the patent claims, but because there were patent claims in the case, the appeal goes to the federal circuit instead of going to the Ninth Circuit. And that's a jurisdictional work that has major ramifications for the case. So it goes up to the federal circuit reverses and remands. Federal circuit says the declaring code and the structure, sequence, and organization of the 37 Java API packages is protected by copyright. Why did they hold that? Well, in infringement analysis, abstraction, filtration, comparison, idea expression is applied as a defense to infringement rather than determining copyrightability in the first place. I think that's an error. Copyrightability is considered initially and considered in infringement analysis, but they said you should consider it as a defense. At the time the Java API was created, Sun had unlimited options in deciding the names and deciding how to structure them into packages and methods, which is quite true. Even short phrases can be copyrightable if they are minimally creative. Some question about that, right? Individual names clearly not copyrightable. Short phrases maybe, maybe not, right? There's a regulation that says short phrases are not protected by copyright, but exact length is, of course, not possible to determine. Selection and arrangement can still be protected. They rejected the Lotus versus Borland case. They rejected Lotus's holding that a method of operation is not copyrightable, even if it is original and creative. And they said it was irrelevant that Android might be interoperable with Java in some way. That was irrelevant to copyrightability. That's clearly not the case under the Ninth Circuit's case law, right? Sega, Sony versus Connect Sticks. Whether something is interoperable is very definitely relevant to copyrightability, but the Federal Circuit didn't see it that way. They said, no, it's only relevant to as a defense to infringement, not relevant to copyrightability. So they reversed and remanded and sent it back for a jury trial on fair use. At the trial, Oracle stipulated that 62 API classes were necessary in order to use the Java language. So that's out of about 3,200 classes. Only 62 they said were absolutely necessary. The rest they said, you could have recreated that using different names. So on the retrial, the jury found that Google's use was a fair use, right? And the district court just handed the whole thing off to the jury. Didn't ask for any factual findings, just a general verdict. Is this fair use? This is not a fair use, right? The jury said it was a fair use, and Oracle immediately moves for judgment as a matter of law, moves for a new trial. Trial court denies it. The trial court said, factor one, the use was commercial, but the jury could have found that the use was transformative, used to create new programs. I'll talk more about transformative use in a bit. Factor two, the jury could find that the code used was not highly creative and that functional considerations predominated. So it's entitled to less protection, a narrower scope of protection. Factor three, the jury could find that Google copied only as much as was reasonably necessary, writing all of their own implementing code and copying only the declarations. Factor four, the jury could find that the market harm was minimal for laptop and desktop computers. And Sun had also not ever gotten into the smartphone market at that point. Now, I should mention, why is Oracle the plaintiff here? Sun Microsystems was a developer of the Java API. And when Google implemented Android and copied this declaring code, Sun Microsystems could have decided to file suit at that point, and they didn't. It appeared that Sun Microsystems thought that this was okay. They thought that even though they weren't necessarily happy about it, they thought it was sort of within generally accepted programming practices to copy interface specifications. And they figured this would increase the pool of Java trained programmers so that it might be good for Sun down the road as well. It was only after Oracle purchased Sun in 2010 that Oracle, sort of a declared enemy of Google in the software computing world, that Oracle decided that they were going to file suit here. So then we got the second Federal Circuit decision. Again, the appeal goes to the Federal Circuit. Second Federal Circuit decision. First thing they do is address the standard of review. Fair use is a mixed question of fact and law. The jury is limited to deciding disputed questions of historical fact, and any jury resolution of inferences or conclusions should be considered advisory only and is reviewed de novo, right? So they're saying the appellate court gets to decide more about fair use than the jury does. The district court erred in failing to grant Oracle's motion for judgment as a matter of law. Factor one, the use was overwhelmingly commercial, and no reasonable jury could find it was transformative because the declaring code performed the same function in both. Factor two, they conceded a reasonable jury could find that functional considerations were both substantial and important. It's the only factor that the Federal Circuit thought went in Google's favor. Factor three, only 170 lines of code were necessary to use Java, but instead they copied about 11,500 lines of declaring code. And factor four, it was error not to find harm to the potential market for licensing the use of the Java API for smartphones. no reasonable jury could find that there was no market harm. So this is the decision that goes to the Supreme Court, and the Supreme Court grants cert. The Supreme Court first asked the Solicitor General whether they could grant cert. The Solicitor General said, no, we don't think you should grant cert. We think this was the right decision. Supreme Court very often follows what the Solicitor General has to say. They went ahead and grant cert anyway. So you can tell at least 4 judges think that there might be something wrong with this. So that's the factual background of the case. That's the procedural posture we're in when the Supreme Court takes the case. Oral argument was postponed because of the pandemic. It was supposed to be heard last March, in March 2020. And because of the pandemic, they postponed it until October. At the same time, they asked the parties to give them supplemental briefs on what the standard of review was, whether the Federal Circuit had gotten the standard of review right, and whether it was affected by the 7th Amendment. The 7th Amendment preserves a right to jury trial in actions at common law above a certain amount. And it says that appellate courts can't re-examine facts, which is true, but appellate courts can, of course, rule on motions for judgment as a matter of law. They can decide whether there's enough evidence to support a finding of fact. But was there a right to jury trial on this issue? So case was re-argued in October, and we got the decision last week. So again, the gist of the decision, we're not going to decide issue 1. We are going to decide issue 2, fair use. But let's take a look at the decision more closely. So first of all, question 1, whether copyright protection extends to a software interface. The court says, well, given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the dispute. Remember, Google wins if they win either because it's not copyrightable or because it's fair use. So we shall assume, purely for argument's sake, that the entire Sun Java API falls within the definition of that which can be copyrighted. And instead, they're going to rule on fair use. So the majority says, well, we're not deciding whether this is copyrighted. Having said that, the majority says a lot about whether it is copyrightable. When they're deciding fair use under factor 2, they said that they characterized the declaring code as a system. They characterized it as a method of operation. They said that if declaring code is copyrightable at all, it's entitled to a narrower scope of copyright protection. So even though we're not deciding that, there's a lot in the opinion that gives sort of strong hints that the Supreme Court doesn't think that this should be protectable. So why didn't they decide the case on that ground? I think Justice Breyer might have been comfortable deciding the case on that ground. Justice Breyer, who writes the majority opinion, it's a 6-2 opinion. Justice Breyer wrote a law review article a long time ago when he was a professor about the uneasy case for copyright, saying that basically copyright isn't economically necessary in a lot of situations because of the first mover advantage. The first person to adopt the program gets a big advantage in the marketplace. Second copiers, even though they can save money on copying, aren't going to get that same advantage. So I think Justice Breyer would have been comfortable. I don't think he had the votes, right? I think other justices were like, maybe they thought that this particular code wasn't copyrightable, but they were hesitant to write a ruling that was broad, that would be broadly applied to interface specifications generally. They like to leave the door open for the possibility that maybe in some other case, the interface specifications might be treated differently, right? They're much more comfortable saying, well, we don't have to decide that, right? We can just rule on fair use. Google still wins. And if there is a case where this isn't a fair use and we really have to rule on copyrightability, maybe we'll decide that. But maybe we'll never have to decide this, right? So I think simply he didn't have 5 votes for saying it was not copyrightable. Whether that broke down on traditional political lines or not, I don't think so. Okay, so that's why we skipped issue 1, and they went to issue 2, fair use. Okay. So whether the jury found, Google's use of the software interface in the context of creating a new program constitutes a fair use. And the first thing the Supreme Court does is address the standard of review, what they asked for supplemental briefing on. Standard of review, the fair use question is a mixed question of fact and law. They agreed with the Federal Circuit that a reviewing court should appropriately defer the jury's findings on the underlying facts, but they agreed with the Federal Circuit that the ultimate question of whether those facts showed a fair use is a legal question for judges to decide de novo. And on the Seventh Amendment right to jury trial does not include the right to have the jury resolve fair use. It's a question of law, not a question of fact. And the Seventh Amendment reexamination clause is not violated by appellate review of a motion for judgment as a matter of law. So what does that standard of review mean? I think the standard of review is the most important part of the decision for future fair use cases. Why? It means that fewer juries are going to be deciding fair use cases. Courts are going to be deciding fair use cases on motions for summary judgment. Fewer situations where we're going to send fair use to a jury. Second, where we do send fair use to a jury, they're going to ask for specific findings. They're going to have special verdict forms where they ask for specific facts to be found to facilitate review instead of just a general verdict, who wins or who loses. Right? And third, it gives the appellate court a stronger basis for overturning these things. So it gives appellate courts a little more power. This is a question of law. Now, of course, when the Federal Circuit reviewed it, the problem was they said they were deferring to factual findings, but they really didn't defer to the factual findings, right? On 3 of the 4 fair use factors, they basically said no reasonable jury could have found these facts. We're not deferring to the jury there. The Supreme Court is much more deferential. So Google's use is a fair use factor. They started with factor 2. This is really interesting. Nobody ever starts with factor 2, right? There's 4 factors. They just discuss them 1, 2, 3, 4. It's very rare to see a court discuss them out of order. But here the Supreme Court starts with factor 2 because they think it's the most important factor in this case. Right? So the nature of the copyrighted work. The Supreme Court said, well, Sun's business strategy was to use the API to attract programmers, so it sought to make the API open and then compete on implementations, right? It wanted programmers to use the Java system. It tried to make the program as easy for programmers to learn and use because they wanted programmers to learn and use their system. And they realized that other people would implement the API differently, perhaps. Unlike many other programs, the court says, the value of declaring code largely derives from the value that computer programmers invest of their own time and effort to learn the API system. Again, here they are characterizing the API as a system. So even though they're saying, we're going to assume it's copyrightable, they're calling it a system, which suggests that maybe it isn't. But the value of that derives because programmers have learned how to use it. And in our view, the declaring code is, if copyrightable at all, further than most computer programs from the core of copyright. Now, Justice Thomas disagrees with this. He said, don't be ridiculous. The declaring code is more expressive than the implementing code. And in a sense, I understand what he means, right? But if you do that, then of course the object code, the ones and zeros, is even more functional than any type of source code. And yet we know that copying the ones and zeros verbatim has to be copyright infringement, even though the ones and zeros are incredibly functional and perhaps all functional, right? But if we're going to protect against verbatim copying, we have to protect the ones and zeros. So just saying that the declaring code is more expressive than the implementing code doesn't really meet the objection that programmers have already learned how to use this. The other thing Justice Thomas says is, well, somebody might have memorized a play already. That doesn't give them the right to use the play without paying for it, which is absolutely true. But plays are for entertainment. Computer programs are functional for accomplishing tasks. And so the scope of protection for a computer program is necessarily going to be narrower than any type of artistic work. Then the court goes back to factor 1. Factor 1, consider whether the use adds something new with a further purpose or different character. altering the copyrighted work with new expression, new meaning, new message. We use the term transformative use or transformative purpose to encompass that. That isn't new, right? That standard comes from Campbell versus Acuff-Rose in 1994. The courts always consider whether something is transformative or not. It's arguably the most important factor since Campbell versus Acuff-Rose, even though before then the Supreme Court has said factor 4 was more important. You can weigh these perhaps differently, but transformative use, very important consideration. Was this transformative? Well, the Supreme Court acknowledges that Google copied the declaring code for the same reason that Sun created it, to enable programmers to call implementing programs to accomplish those tasks. Now, usually this would be a big strike against you, right? If you're using it for a very different purpose from the original, that might be transformative, that would weigh in favor of fair use. If you're using it for the same purpose of the original, that's generally not considered transformative and is not considered a fair use. But again, the Supreme Court's view is colored by the policy question. You know, programmers have already learned how to use it. And Google then used it to create a new platform that could be readily used by programmers to create their own programs without having to learn new commands. And the Supreme Court, the majority, sees this as unlocking a lot of programmer creativity, right? That programmers can write lots and lots of new things because they already know these old commands. And in order to take advantage of the new and improved Android platform, it makes more sense, it's more efficient for them to be able to use it without having to learn new commands. And although the use was commercial, many common fair uses are commercial, such as news reporting, right? So this is consistent ever since the Campbell case in 1994. Supreme Court has downplayed the element of commerciality in deciding fair use cases. Lower courts have downplayed the element of commerciality. Used to be far more important. Transformative use is the more important consideration under the first factor. Third factor, factor 3, Google copied 11,500 lines of code. That sounds like a lot of code, but when you compare it to the whole Java API, it's not that much. The district court kept using 3%. That out of the 37 packages at issue, the declaring code only constituted 3% of the code. The implementing code was 97% of the code. The Supreme Court uses an even smaller number. They said, well, if we look at the whole Java API, if we look at the 166 packages, only about 0.4%, 0.4% of the total lines of code were used. That's a very small percentage. This is consistent with fair use, using a small percentage of something in the course of creating something new, like a review of a book or a review of a movie, or a parody or satire. That's going to be more likely to be a fair use. Second, the Supreme Court says the substantiality factor will generally weigh in favor of fair use, where the amount of copying was tethered to a valid and transformative purpose, as here, right? So again, because it's transformative under factor 1, that affects our analysis of factor 3. And Google copied these lines not because of their creativity or their beauty. It copied them because programmers had already learned to work with the Sun Java API system, and it would have been difficult to attract programmers without it. And of course, you know, again, Justice Thomas is like, attracting programmers is the whole thing. You should have to compete on your attractiveness to programmers, whereas the Supreme Court says no, right? You should be able to use interface specifications and compete on implementations. And then finally, our fourth factor, the effect of the use on the market. Supreme Court says consider not only the amount of money that the copyright owner might lose, but also the source of the loss and the public benefits that the copying will likely produce. And here, Justice Thomas, dissenting, goes sort of ballistic. He says, look, Sun Java lost a huge amount of money. It could have made a ton of money by licensing the Java API. They lost that. They lost their edge in the smartphone market. And conversely, Google profited. Google made a ton of money off of this. And he sees that as unfair. The Supreme Court doesn't see it as unfair because, again, the jury could have found that Android did not harm the actual potential markets for Java, and that Sun would not have been able to enter those markets successfully, whether Google did or did not copy, right? So the jury could have found that market harm didn't exist. They reject the argument that Google's effort to obtain a license should be held against it for a couple of reasons. First of all, they said, look, they were negotiating over a lot more than just the daring code. They were negotiating for a license to use the entire API. They were negotiating for a license to use the Java name as a trademark, right? So they would have gotten a lot of benefits if they'd licensed. When they decided not to license, they didn't just copy the whole thing. When they decided not to license, they copied only what was necessary for, they only copied only what was necessary for programmers who'd already learned the names of those methods. And they wrote all of their own implementing code, right? So they weren't, the negotiations were about something that was much broader than what they ended up copying. So that's not an admission that what they ended up copying was copyrightable. Second, of course, there's a passage in the Campbell case, footnote 18 in the Campbell case, which says, even if they ask permission and don't get it, use it anyway, that shouldn't be held against you. We want to encourage people to ask permission. Asking permission isn't an admission of guilt. It's not an admission that you need a license. It's just we want to avoid litigation, right? So we want to encourage people to ask permission. We want to encourage people to try to avoid litigation. So if you ask permission and you don't get it, that should not be held against you. Footnote 18 in Campbell, worth remembering. And again, going back to the basic policy issue, the Supreme Court says, we have no reason to believe that the Copyright Act seeks to protect third parties' investment in learning how to operate a created work. Again, characterizing it as a method of operation. So the bottom line, very narrow ruling necessary to decide the case, right? Bottom line, where Google re-implemented a user interface, taking only what was needed to allow users to put their accrued talents to work in a new and transformative program, Google's copying of the Sun Java API was fair use of that material as a matter of law. So that's our holding in the case. Okay. So what are some of the implications? Well, first of all, this case should have been decided 25 years ago when Lotus, Borland versus before the court. It wasn't decided then only because of the recusal and the affirmance by an equally divided court. But in that ensuing 25 years, programmers pretty much accepted that interface specifications weren't copyrightable. So the Federal Circuit's opinion saying that they were, had that been upheld, that would have been incredibly disruptive. Instead, the Supreme Court more or less restores the status quo by saying that it's a fair use. I would have preferred that they ruled on Section 102B grounds, but would have preferred they ruled on copyrightability grounds, because if it's a fair use, you have to litigate longer, right? There's more uncertainty, there's more time, there's more cost, there's more litigation involved. But nonetheless, I think it's an alternative way of reaching the same result, that basically they were allowed to reuse the interface specifications here. Again, remember that when Sun Microsystems owned Java, they didn't think that this was a problem. Sun's CEO testified that he didn't think it was copyright infringement for Google to take the interface specifications, the declarations from the Java API. Again, Sun wasn't necessarily happy about it, but they thought it was okay. It was only after Oracle bought Sun that you see a copyright infringement lawsuit. And that's because, of course, laches is not a defense in copyright infringement. That's a Supreme Court case from a few years ago, Petrella versus MGM. So basically, any new infringements within a 3-year period keeps the statute of limitations alive. It's a huge win for Google, obviously. It's very important to the software industry, more or less restores the status quo to where it was before the Federal Circuit's opinions. My opinion, and I said this in the blog post, my opinion is that it's unlikely to drastically affect fair use cases outside of the software industry. And the reason I think that is because the economic considerations, the policy considerations that lead the Supreme Court to say that this is a fair use, the fact that programmers have learned how to use this already, I don't think those are going to be very applicable outside the world of computer programming. So I think this is a fairly idiosyncratic opinion, huge for the software industry, but I don't see it having a lot of effect outside the software industry. Obviously, it will be quoted. The standard of review, I think, is very important for future fair use cases. A few general remarks, such as consider the public benefits in deciding factor 4 market harm in addition to the harm to the market. But basically, overall, an important decision for software. I doubt it's going to have a huge impact outside of software. And then finally, as I said in my blog post, I am struck by how many times Google has taken a very aggressive position on copying and fair use, and ultimately has been vindicated in the courts. So if you think about all of the litigation that Google has been involved in fair use over the years, and I just made a quick list, extensive automated copying of websites to enable the Google search engine. That's been upheld in Field versus Google in 2006, Parker versus Google in the Third Circuit in 2007. Extensive automated copying of images to enable Google's image search engine. Perfect 10 versus Amazon case, but Google was the defendant that took that to the Ninth Circuit. That was held to be fair use. Extensive automated copying of library books that were not already online to enable Google book search. And it's difficult to remember, but back when that was announced in 2004, Google book search was incredibly controversial. But it took 2 appeals to the Second Circuit before the Second Circuit finally held that that was a fair use. And then here, copying the declaring code from the Java API, that takes 2 trips to the Federal Circuit and a trip to the United States Supreme Court before they say that that's a fair use. So Google is the 600-pound gorilla in fair use, right? They are taking very aggressive positions that lots of copying enables sort of technological progress, and they have lots of litigation, which is very expensive for them, but ultimately they are successful, and they've shaped a lot of fair use jurisprudence for years to come. Okay, so that's my talk, and I'm gonna take questions here. So let me ask Michael and Indo. You guys want to moderate these questions out of the chat room, or do you want me just to take them from the chat room directly and start talking about them? There's a lot of questions here, but I'm happy to stick around for a little bit and answer them. What would you guys prefer?
We put them all in a document, so we'll just be sending them to. Yeah, this might drizzle over the 7 o'clock time frame, so anyone that has to hop off can do so. But without further ado, I'll be sending them to you on the chat and private message, so you can get to them right now.
Okay. Well, I can see the chat questions here in the order that they were asked, so that's not a problem. One of the questions that was asked is, why didn't they decide the copyrightability issue? And I think I answered that question. I think Justice Breyer would have liked to, but I just don't think he had the votes. So he did have the votes on fair use, and he figured he could get to essentially the same result. And I talked a little bit about declarations in code. We've had a lot of people saying interface specifications, right? Comment here that Google re-implemented the API. They stipulated a copy of the declaring code. It's much easier to make compatible declarations using a program that Oracle distributes expressly for this purpose, the Java P program. They wouldn't necessarily have to copy in order to do that. Whatever, they stipulated to copying the declaring code, or the jury found that they had copied the declaring code, so that's easy. I'm getting a lot of really technical questions here in the chat room. Vaccines involve a chain of DNA, RNA reactions to achieve a given result. That kind of API might also be subject to this. If DNA was copyrightable, if biological processes were copyrightable, perhaps. We haven't had any cases that have held that DNA or RNA is copyrightable. As a product of nature, I would doubt it would be copyrightable. That's really in the realm of patent law, And the statutory scheme in patent law, of course, is very different. Supreme Court did, of course, hold that naturally occurring DNA sequences were not patentable subject matter, but artificial DNA sequences could be patentable subject matter. So I would expect there to be some scope for protection in patent law for vaccines, but not in copyrightability, as we do here. Okay. Later cases can still reach the issue of copyrightability. Yes, but I don't expect them to, right? Because now we know it's a fair use. So later cases can do the same thing that the Supreme Court says and says, okay, I'm going to assume it's copyrightable, but if it fits within this fair use framework, I'm going to say it's fair use. We don't have to reach copyrightability. We really only have to reach copyrightability if we don't think that the use is fair. And I realize that that's doing things backwards. In fact, Justice Thomas complains that they're doing things backwards. He says, look, how can you do a fair use analysis without deciding what the scope of protection is here, right? You need to decide whether it's protected first and then decide whether it's fair use. I agree with him as a matter of theory, right? That's the preferred way to do things. But you know, he's not in charge here, right? The Supreme Court says, yeah, no, we can go ahead and decide fair use, even though we haven't decided it's copyrightable. We assume it's copyrightable, but our factor 2 analysis nonetheless suggests that the scope of copyright should be much narrower. How will this affect music infringement cases where juries have been expected to read and understand sheet music evidence that may suggest substantial similarity to those that know nothing about music? You can have expert witnesses in music infringement cases, just like you can have expert witnesses in computer infringement cases, where experts are necessary in order to help the jury understand things. You can have expert witnesses in those things. Music cases are very often decided on copyrightability grounds rather than fair use grounds. This might encourage more judges to decide music cases on fair use grounds instead of sending it to a jury, so it might affect music cases in that way. Transformative use isn't the entirety of the first factor. No, it isn't, but it's a really important part of the first factor. And here again, the Supreme Court says it is the most important consideration, and commerciality, which is actually mentioned in the statute, they decided it was much less consideration. Somebody's asking me questions about the API to Google Maps, and sorry, I don't have the technical expertise to address that one. Somebody comments that Thomas always says Oracle and Breyer always said Sun, right? That's because Sun Microsystems is the one who created this. Oracle is the one that sued about it after they purchased Sun Microsystems. So, you know, if you're trying to make somebody look good, right, you know, you're stealing stuff from Oracle, makes Oracle look better. You know, Sun Microsystems didn't mind that you took this stuff. It was only Oracle that did, right? That tends to make Google look a little better. Okay. So lots of comments in the chat room rather than questions. Does this perhaps foretell a more copyright skeptic Supreme Court? I don't think so. Breyer certainly is a copyright skeptic and has been for a long time, but he's lost a lot of decisions 7-2 when Justice Ginsburg was still on the court. And so even though Breyer's a copyright skeptic, I don't think in general the Supreme Court is skeptical of copyright. It's not something that breaks down along traditional political lines. You very typically see, you know, for example, when Ginsburg was on the court, Ginsburg was very strong on copyright protection. Breyer was always stronger for public domain considerations, typically voted for defendants in copyright cases, not always, but typically. So, you know, I think it's going to depend on the type of case. But with computer software, I think the judges knew that Breyer knew a lot about computer software and were sort of willing to defer to his judgment and to the lots of amicus briefs from the software industry, most of whom favored Google here. Yes, the 6 members of the majority were 3 so-called liberals, 3 so-called conservatives. I'm glad to see it was a 6-2 decision. It means that Justice Ginsburg's absence didn't affect it. Justice Barrett's absence from the oral argument didn't affect it in any way. It appears, right, would have come out the same way. What impact do I think it'll have on software patents? Not much. I do think the Supreme Court has been very skeptical of software patents in general. And the Alice decision certainly reflects that. Alice is just a mess, right? The software patent area, the decisions involving Alice and the lower court decisions interpreting them, just a mess. Supreme Court, I mean, you know, on the one hand, they should take a case to try to clear it up. On the other hand, I'm not sure it would clear it up any better. You know, Alice, very messy. It's sort of a shortcut for deciding grounds on things that look like intuitive Section 103 non-obviousness decisions. It's a real issue. How do I think Justice Ginsburg would have voted? Almost certainly she would have voted for strong copyright protection. She did so very consistently in her years on the court. I think very likely she would have voted for strong copyright protection. Comment that she would have written a better dissenting opinion than Justice Thomas. Probably true. Why do I think the Federal Circuit got so wrong? I don't know, but the Federal Circuit, being partly a specialized patent court, decides a lot of patent cases and might be seen as sort of pro-patent protection, right? They tend to uphold patentability when it comes to them more often than not, even though it's a mixed bag, but certainly more often than the courts of appeals did before patent appeals were centralized in the Federal Circuit. And the Supreme Court more or less left the Federal Circuit alone for 20 years. And then when they started reviewing patent cases again, they're like, whoa, what are you guys doing? And the Supreme Court kept reversing the Federal Circuit unanimously. And the only cases where they didn't reverse the Federal Circuit was when the Federal Circuit saw the writing on the wall and sort of reversed themselves first. So the Federal Circuit is becoming the Supreme Court's favorite target to diss, right? They just keep reversing them over and over. And you'd think they'd get the message eventually, but they clearly haven't, right? Okay. Lines of code is not a particularly meaningful term. That's quite true, right? You know, lines of code depends on how long you print something out for. You know, and you can put stuff on multiple lines and it really doesn't matter as far as the compiler goes. Why are we using lines of code or not, right? You know, it's just a convenient way for people to refer to it. As long as we're all using the same denominator, it can work out. More questions. Procedurally, could the case go to the Ninth Circuit when the patent claim is dropped? No, it couldn't. It had to go to the Federal Circuit. And even though the Federal Circuit claimed it was applying Ninth Circuit law, it wasn't. I'm quite confident the Ninth Circuit likely would have reached a different decision. Okay. To what extent does deference to the jury's findings of fact control the outcome on the factor 4 test? That is interesting. When the Supreme Court reviews factor 4, they're like, well, the jury heard this evidence, the jury could have found this. And the jury's decision in their favor means that even though there was conflicting testimony, we shouldn't overturn it. So for factor 4, they're deferring to the jury. For the other factors, they were sort of more definitive. So kind of important there. So I think that takes care of most of the questions in the chat room. But in any case, I appreciate you coming by and sticking around. This lecture will be recorded or has been recorded. We are going to make it available on YouTube. Somebody asked if I'll make the slides available. Yeah, I'll be happy to do that. And thank you for attending. I hope you learned something about software. I hope you learned something about Google versus Oracle. And I hope that helps you in addressing future cases about copyright. So thanks very much.
Perfect. Yeah.